There are municipal courts in the largest and smallest cities in Texas. The caseloads and operations of these courts vary as widely as the populations of the cities in which they are located. But no matter the size or number of cases, all municipal courts are part of the Texas judicial system, and every one of these state courts is governed by state law. These hundreds of municipal courts administer justice across Texas every day, and whether a person is a juror, a party in the case, or simply a resident of the city, they will have a lasting impression of the entire Texas judicial system based on their experience in municipal court. Because in Texas, more people come into contact with municipal courts than all other Texas courts combined. This video is not only for municipal judges and court support personnel, but also for other members of municipal government and for members of the public who are interested in the role of the municipal court. In addition to courts expressly named in it, the Texas Constitution authorizes the Texas Legislature to create other courts by statute as it deems necessary and to prescribe their jurisdiction. In 1899, the legislature by statute created municipal courts in each incorporated city in the state. These courts have original jurisdiction over violations of municipal ordinances and concurrent jurisdiction with the justice courts within the geographical confines of the municipality of state law Class C misdemeanors, criminal offenses where the sentence entails the imposition of a fine and court cost. There are more than 1,300 Class C misdemeanors defined in state law. In addition, thousands more Class C misdemeanors are created by city ordinances, making this type of misdemeanor the most common type of criminal offense in Texas. In addition to offenses in the penal code, Class C misdemeanors exist in a wide array of other state laws. Although Class C misdemeanors are not as likely to get press coverage or become best-selling crime novels, they are nevertheless very important to our communities. Imagine a community with no traffic laws, where minor thefts and assaults go unpunished, where public drunkenness and disorder rule the day, and nuisances continue unabated. Class C misdemeanors permeate our daily lives. Although we may not always appreciate their importance, the enforcement of seemingly minor offenses plays a major role in maintaining public order and quality of life in Texas. Municipal judges make up 36% of the entire state's judiciary. Like all other judicial office holders in Texas, municipal judges are public officials, not employees. Unlike other judges in Texas, state law allows cities to choose to either elect or appoint municipal judges. The term of office of a municipal judge is 2 years, unless the municipality provides a longer term pursuant to Article 11, Section 11 of the Texas Constitution. Unless elected, at the end of the judge's term of office, it is up to the city government to affirmatively decide whether to reappoint the municipal judge. Absent action by the appointing authority, on the 91st day, a municipal judge is reappointed for another term of office by operation of law. Because municipal courts are locally funded, operated, and administered, it is easy to understand why city officials and employees may mistakenly think of municipal courts as a city department. Although municipal courts often appear in various configurations in city organizational charts, it is critically important that cities understand that there are legal distinctions between hosting a state trial court and operating, for example, a police department, a fire department, or city commission. Municipal courts are state courts, and their judges are controlled by the same rules as all other state judges. Under the 14th Amendment of the United States Constitution and state law, all criminal defendants have the right to due process of law, which includes a fair and impartial judge. The requirement of an independent judiciary is clearly set forth in the preamble to the Texas Code of Judicial Conduct. Its very first sentence reads, "Our legal system is based on the principle that an independent, fair, and competent judiciary will interpret and apply the laws that govern us." Judicial independence entails courts operating free from the improper influence of other parts of government, including employees and officials, and both private and partisan interest. In the context of municipal government, judicial independence means that municipal courts must not act or be expected to operate as a rubber stamp for the mayor, city manager, police department, or any other city agency. Regardless if it's in a big city or a small town, or whether court proceedings are held in city council chambers or a separate building, judicial independence involves maintaining a distance between City Hall and the municipal court. Judicial independence does not mean that City Hall should ignore what is happening in the municipal court. To the contrary, public accountability and judicial independence go hand in hand. The public is counting on City Hall. Judges should not act like prosecutors or defense attorneys. Clerks should not usurp the authority of judges or become proxies for either law enforcement or the finance department. When it comes to municipal court, the duty of loyalty of a mayor, a city council member, and other local officials is to the public and its interest in justice. While crime does not pay, Class C misdemeanors generate revenue for state and local governments as an incidental byproduct. The integrity of municipal courts in Texas hinges on the public maintaining confidence that fairness, justice, public safety, and the rule of law, not revenue generation, as the reason such courts exist. The imposition of quotas, which evaluate the court based on its ability to generate revenue, threatens the integrity of courts that impose fines as punishment. Section 720.002 of the Texas Transportation Code prohibits the use of citation or income quotas to evaluate, promote, compensate, or discipline an officer or municipal judge. The creation or use of such a plan is grounds for removal of the city official that promulgates or sponsors it. Article 45.201 of the Texas Code of Criminal Procedure provides that all prosecutions in a municipal court shall be conducted by the city attorney or by a deputy city attorney. That section also provides that the county attorney may volunteer to take the role without compensation. Finally, the section goes on to instruct prosecutors that their primary duty is not to convict, but to see that justice is done. All other Texas prosecutors share this same duty. When prosecuting, city attorneys represent the state's interest in enforcing the law. That means seeing that justice is done, not being concerned with revenue. Prosecutors are responsible for deciding what charges to bring, the language used to charge the defendant in the complaint, when to recommend dismissals, when to plea bargain with defendants, when to interview witnesses, what witnesses to call, and which cases to take to trial. Municipal judges have three different kinds of duties: judicial duties, administrative duties, and magistrate duties. Judicial duties entail ensuring due process, being the impartial arbiter of law and facts, and making decisions in a fair and just way under the rule of law. Judicial duties include requesting and accepting pleas, making and rendering judgment, setting fines, choosing between legal alternatives, making decisions of law, making decisions of fact in pretrial matters and in trials before the judge, instructing juries, ruling on objections at trial, setting or forfeiting bail, granting or denying motions, granting and revoking deferred dispositions, and making decisions about the enforcement of judgments. Administrative duties are often shared with court clerks and other court support personnel. Such duties must be diligently and promptly discharged as required by the Code of Judicial Conduct. Administrative duties include managing dockets to promptly dispose of cases in the court, guiding the operation of the court and its staff, dealing with financial reports and money, preparing budgets, and coordinating with law enforcement. Magistrate duties are a product of state law. A magistrate's authority is generally countywide. The authority of a magistrate is distinct from the authority of the municipal judge. By virtue of their office, municipal judges serve as magistrates in the county or counties where their city is located. All judges in Texas are magistrates. However, how these duties are performed can vary from county to county throughout the state. Unlike judges who are involved in the stages of a criminal case after the commencement of formal charges, magistrates are generally involved in the preliminary stages of the case prior to formal charging. Upon the presentation of a sworn affidavit establishing probable cause, magistrates have the authority to issue arrest warrants for misdemeanors and felonies alleged to have occurred in the county. Similarly, all magistrates in Texas are authorized to issue search warrants for fruits of a crime, instruments of a crime, and contraband that is not subject to forfeiture. As neutral and detached public officials, magistrates serve as an institutional safety mechanism that protects the public from unreasonable searches and seizures. In the context of mental health, magistrates have the authority to issue an order of emergency apprehension and detention. A magistrate may also order a mental health assessment of people in jail custody. After an arrest for either a misdemeanor or felony, Article 1517 of the Code of Criminal Procedure requires the person arrested to be promptly presented before a magistrate. Texas has no formal label for this initial appearance before a magistrate. It is sometimes mistakenly referred to as an arraignment. It is more accurately described as the Article 1517 hearing, or by the colloquialism magistration. Because of the time-sensitive nature of the presentation required by Article 1517, magistrates regularly work on weekends and at night. The Article 1517 hearing is important because it has implications on constitutional rights. It combines the Fourth Amendment's required probable cause determination with the setting of bail. It is the point where the magistrate formally informs the defendant in custody of the basis of their arrest. It is also the stage where, in addition to other things, defendants are told of their constitutional rights, including the right to counsel and the right to remain silent. When bail is allowed, the magistrate may also set conditions on bail. For example, a magistrate may require a person accused of repeated DWI violations to install an ignition interlock device on their vehicle. In cases involving family or dating violence, the magistrate may also be required or have the discretion to issue a magistrate's order of emergency protection. These orders prohibit the defendant accused of family or dating violence from going to certain places, contacting or harming alleged victims. In cases involving an arrest for a felony, a magistrate may be required to conduct an examining trial. An examining trial is an adversarial hearing where the prosecutor must establish probable cause in a trial-like setting. Finally, a magistrate plays an integral role in obtaining an admissible confession from a child suspect in law enforcement custody. Such a confession, which can only be taken in a designated juvenile processing office, entails the magistrate warning the child of their constitutional rights and determining that the child is voluntarily and intelligently waiving them. Public perception goes hand in hand with public confidence. Evidence suggests that the key to promoting public confidence in the legal system and in our courts is to be mindful of perception and for the government to increase its focus on fairness. In the context of courts, fairness means treating individuals with dignity while openly respecting their rights. It means providing an opportunity for people to express their own viewpoints. Fairness requires that legal principles be applied in an unbiased manner and ensuring that members of the public understand their legal rights and the court process. A fair and proper procedure helps reach a fair and correct decision. Furthermore, when people feel they are treated fairly, they are more likely to comply with court orders and more accepting of legal outcomes. This requires courts to affirmatively take steps to ensure that the public can perceive a court's commitment to doing individual justice in individual cases. Remember, Texans are more likely to have contact with their municipal court than all other Texas courts combined. The public's trust and confidence in the state judicial system depends on both the reality and the public's perception.